Basically, there are two takeaways that I wanted to give with my presentation on patent enforcement strategies. The first takeaway is that when you are facing a patent dispute, you should always wonder, who is my opponent? Is it a competitor or is it a company who we say is a non-practicing entity? If it is a competitor, there are a couple of options available to you for settling a dispute. You can either settle for money, you can settle for cross-license, you can settle for market shares, you can make agreements about client sharing, about market sharing, or splitting up the market if it is legal from a competition point of view. However, if you are facing a non-practicing entity, that's a very different ballgame. We sometimes call it as litigators a live or die game, because actually that company has nothing to offer in return. They want money, and all you settle for is money. And that makes the situation very different and the patent dispute a lot more different to pursue. The second takeaway is that, and that's very important after 30 years of practice that I can witness as a big recommendation, a big advice, is that you must stay in the driver's seat. If you are facing a patent dispute, don't wait until you get sued. Don't wait until your opponent takes initiative. You must be in the driver's seat. You must, as we say, draw first blood. Because by taking initiative, you will determine, first of all, the venue of the dispute. Where do I sue? In which country? Before which judge? In what jurisdiction? What cultural legal background do you choose to bring your dispute? Secondly, and that comes automatically with the first choice, what is the speed and therefore also the cost of your dispute? And then you create many more options that you can determine for settling the dispute than if you passively wait. Typical mistakes are, first of all, personalizing the dispute. Very often SMEs are companies with a very core patented technology that very often is invented and owned by the CEO, by the manager of the company. And when they are attacked or when they want to attack a competitor and their patent is questioned, these people take it very personally. It is as if they are being attacked in their very essence of their personality. And as a lawyer, as a counsel, you must assist those companies in depersonalizing a dispute. You see it in two ways. You see it when the patent is disputed, when they say it is not valid, your invention is not good. The inventor takes that very personally, and that taints the whole dispute. Sometimes it makes a settlement impossible. Also during discovery and disclosure, when you have to give to the other side all your information away, which in business is very normal to do in certain practices, for an SME sometimes that is considered as a straight personal attack, as if you were taking or attacking the intimacy of a company. And you see the management of a company then, of an SME company, reacting very, very awkwardly and saying, no, we can't do that. This is giving away our trade secrets, this is giving away the most valuable information which we have. Whereas typically, that is what is very often the case in these disputes. You must do that. But by making the dispute so personal, this can sometimes be an impeding factor on the further pursuit of the litigation. The second error that I often see make is the personalization of a dispute, when very often the CEO or the manager of the company is also the inventor, the main investor in the company. And when he gets sued, or when his company gets sued, he takes it personal and it becomes his dispute against the other side. And then he lacks delegation powers. He starts to take care of all aspects of the dispute, starts reviewing all the documents, starts to make all the studies, tries to develop all the legal arguments, tries to also to do all the research, not delegating enough to his team. And in the beginning, he has then the feeling of having some control and more control of the cost and the strategy. But after a few months, and certainly after a year, which a litigation can easily take, he is totally consumed. He has so much management time to invest in the dispute that he actually no longer can run the company. And that is where your role as outside counsel is very important, because what you can do there as outside counsel is to act as a filter, to make sure that your client is not consumed all the time with conference calls and meetings that relate to the dispute, but that you can accumulate the information that is necessary and that you can transmit the really need to know information to the other side. That is the first role. And then the second role is also to making sure that you have a team around you and not just one person to deal with. Because if that one person at some point in time is unavailable, and that will inevitably happen, you have no one else to rely on and to receive information from. And that is a second role as a council, that you must make sure that there is a team that can assist you within the SME and not a single person. I'm talking there from the perspective of a civil lawyer. So I'm talking here for SMEs who come from Germany, Holland, France, Belgium, Eastern Europe. They are not used to what we call in the common law systems, of which Ireland and the United States and the UK are part of, is the system what we call disclosure or discovery. It is the obligation for a party in the dispute to give all relevant information to a dispute. And certainly in the United States, where discovery is the rule, that can go very far. So business plans, financial information, laboratory notebooks, all sorts of information has to be disclosed to the other side. And that is very badly taken by SMEs. They feel this as a personal attack on their privacy or on their really trade secrets. And also there you must manage as an outside counsel that concern, that reaction of, no, I cannot do that, this is too secret or this is too personal to me, what does this have to do with the dispute? I often experience this as the worst nightmare for companies, smaller companies who have for many, many years worked on a product, on a technology, secretly or in big confidence in their own technology, and all of a sudden they have to give it away, or they have the feeling that they have to give it away, to disclose it to someone who tries to break up their company. And that psychological fear is a big factor that you have to deal with as outside counsel, and to make sure that this information is protected by the necessary protective orders or by confidentiality, or just trying to convince your client that it is not all that confidential, that very often most of these business plans will be either not read or will be recognized as being pretty standard. But for the SME, nothing is standard because they have never experienced such an experience before. And so they think that this is very aggressive and they don't want to cooperate. And then you are in trouble. And as outside counsel, your role is precisely to avoid that trouble.